Good evening, everybody. Sorry for the delay in getting in this video. YouTube had an issue with the first one I uploaded, and so we are trying this a second time. Last class, we talked about judicial review, basically a power that the court granted itself to declare legislation unconstitutional. And you might think that this is a trend that was going to go on throughout history, that the court would continue to take more power, just declaring that they have it, and nobody would really say anything. This, however, really couldn't be further from the truth. In this lesson, we are going to talk all about the limits on judicial power that the court kind of imposes upon itself, and what that looks like. For this class, there is not any homework. There are probably at least a dozen landmark cases that we could go over to prepare for this class, but I'm more interested that you grasp the concept of what sort of cases the Supreme Court will say, no, we're not going to hear this, than having you read a whole bunch of stuff. We're going to hop back into reading cases for next week, though, with when we begin talking about federalism. And to do that, I'm going to have you read McCulloch versus Maryland and United States versus Comstock. McCulloch versus Maryland is a landmark U.S. Supreme Court case from 1819. United States versus Comstock from 2010. So again, I want to try and get you some information from history and some information that's a little bit more recent. Before we begin talking about what sort of things the Supreme Court won't hear, it's important that we understand a couple of basic ground rules sort of things, and that's that there are two types of jurisdiction out there. And when we say jurisdiction, this is broadly going to mean a court's ability to hear a particular case. With jurisdiction, we have subject matter jurisdiction. This is the court can hear the case or this particular type of case. The facts involved are something that this court can actually address. Personal jurisdiction, on the other hand, is going to be that the court has power over the individuals involved. For example, if I live in Illinois, do all my business in Illinois, and never come to Missouri, Missouri courts don't have personal jurisdiction over me. There may be a case that they have subject matter jurisdiction over, but they can't actually haul me into court because they don't have personal jurisdiction over me. That said, personal jurisdiction can be waived. Let's say that Missouri, I want to sue somebody, a Missouri court has subject matter jurisdiction, and Illinois says, no, we're not going to have this sort of case. Well, I might want to bring that case in Missouri, and if everybody can waive personal jurisdiction, then we can have that case in Missouri. On the flip side, subject matter jurisdiction can never be waived. A court does not have authority to act if it does not have subject matter jurisdiction. When we think about subject matter jurisdiction, there are all sorts of cases, like we saw in Marbury versus Madison, that the court is going to have original jurisdiction or appellate jurisdiction over. When we talk about standing, this, to a large extent, comes from the Constitution, and it's several different requirements that you have to meet in order to bring a case in court to begin with. We say in order for a case to come before a court, the parties must have standing. Standing consists of several parts. The first is injury in fact. And don't let the fact that this is one slide confuse you. While this is the majority of the lesson, this one side is packed with information that you need to know. An injury in fact means that somebody got hurt. Now, that doesn't mean a physical injury. It could be a financial injury. It could be deprivation of liberty. There are lots of different ways that injuries may occur. The fact of the matter is that somebody's going to have to be injured. We'll talk a little bit more about that when we get down to ripeness and mootness in just a minute. Second, there's this idea of causation. The person you're suing has to have actually caused the injury in fact. I can't, for example, slip and fall in my home and sue Lincoln for damages, saying that I have standing because Lincoln in no way caused that injury. And finally, we have redressability. Redressability means that it is not just a guess, but it's more likely than not that there is some sort of remedy that is going to fix the problem that has occurred, whether it's compensation or restoring liberty, but there's got to be some remedy that exists that can fix the problem. And then we have ripeness and mootness. And do not worry, once I've defined all these terms, we're going to walk through it with an example. And we're going to do that because, it really doesn't make sense until we actually go through and use an example or two. Ripeness means that the injury in fact has not yet occurred, or something's ripe when the injury in fact has actually occurred. Things are not ripe before that point. Roe versus Wade is going to be a perfect illustration of ripeness versus mootness, so we are going to get there in just a minute. Second, we have the case is no longer, mootness is where the case is no longer redressable. So whereas ripeness means we don't yet have that injury in fact, mootness means that we have lost the ability to solve the problem. Let's talk about Roe versus Wade. We are not going to discuss whether or not abortion is right or wrong, but it is an important thing to consider for the practice of standing because it is something that evades judicial review. And the court, in fact, in Roe versus Wade creates an exception around the standing requirement. We'll talk about that at the end to kind of wrap this all up. But if we think about a pregnant woman who would like to have an abortion, and we pass that fact pattern through this test, we aren't going to have an injury in fact until her request for an abortion is denied. So we have to wait until, okay, that's been denied. The causation is going to, of course, be there because whoever denied it is causing her to not be able to have that procedure performed. And that says repressibility. That should be redressability. Let me fix that really fast. Done. It should be one word, but we'll fix that later. It is going to be redressable because in the event that the court can act fast enough, then they can basically overrule whoever is saying she can't have the abortion. However, this is where ripeness and mootness really comes into play. With Roe versus Wade, a case isn't ripe for review until that person has been denied the ability to have an abortion. So women who might want to get pregnant, women who have been pregnant and want to get pregnant again, they're not going to have suffered an injury in fact yet, and therefore the case is not yet ripe for review. Mootness comes to play because if the redress we are looking for is to be able to get an abortion, many times the court is going to reach the conclusion of a case after the baby's been born. When you think about how long our judicial process works, and then remember that pregnancy is at most 10 months long, give or take a couple of weeks, you come out to the conclusion that it is very likely the baby's going to be born in here before the case can be addressed. And this is what happened with the cases that preceded Roe, and that's that many of them were dismissed as moot before the court actually got to hear anything about the case. They didn't get to hear arguments or anything like that. With Roe versus Wade, they created an exception that basically permits cases evading judicial review to be brought before the court. So Roe versus Wade was heard despite the fact that what was done was already done. But, more or less, this doctrine is still used in many cases today. Similarly, you can't fix the problem and then say, oh, well, but court, you have to dismiss this because it's now moot. For example, if I am actively hurting your grade, if I am unjustifiably giving everybody zeros, and you all decide you're going to sue me in a class action, and it gets to court, and I say, well, but Judge, I changed all their grades to A's. This case is now moot. No, it doesn't work that way. You can't try and stymie the system by getting out of it. There are lots of cases like this. Walking through a couple of more. One of the famous cases that deal with from torts is a guy on a platform on a train station where a kerosene lamp breaks and burns him horribly badly. He sues the train station basically because it's their lamp. I think an animal kicked it or something like that. So in this case, was the man injured? Absolutely. Did he suffer from his injuries? Yeah. We're going to be able to, it's actually occurred, so it is ripe. The man's still alive. He hasn't spontaneously been healed by some sort of miracle, so it's still moot. It's not moot yet. It is redressable. He can get damages from the train company or from anybody else to try and pay for his surgeon and stuff like that. But we have a problem when it comes to causation. With a tort, this would be something factually they'd probably argue, but if it's not caused by the person you're suing, you can't bring it. Let's look at this from a different point of view, just to kind of illustrate that causation chunk one more time. Suppose that you miss more than 6 classes, which doesn't really apply here since it's an online class, and Lincoln University administratively drops you from the class. You sue me and say, Andrew, I shouldn't be kicked out of your class. Is this going to, do you have standing to sue me? And the answer is probably not. There's some respondent superior stuff that gets far too complicated for the scope of this. But realistically, no, because Lincoln University is the person who injured you. Lincoln University is the person who has power to fix you. Andrew doesn't. As the instructor of this course, I don't have the ability to re-enroll you or to change that administrative drop policy. And then finally, with redressability, this is going to be something where sometimes there are cases that all other things fit. It is not moot. It is definitely ripe, and yet it's still not going to be redressable. Therefore, the court doesn't have jurisdiction over the case. Something like this might be when we're dealing with an ambassador. With an ambassador, the court can't get personal jurisdiction over that ambassador, typically. I don't know if you guys have heard about this, but lots of times political figures visiting the United States enjoy an absolute immunity. So much so that if you go to D.C., you'll walk around and see parking tickets all over the place for with cars that have ambassadorial plates because they don't care. They're not going to be able to take any action against them. Basically here, yeah, you might have a great case. There might be an injury in fact. There might be causation. The case is ripe. The case isn't moot. But you can never sue that ambassador because they don't have to respond to the subpoena. So redressability is going to be something that occasionally stymies the situation too. All right, there are 2 more areas that we need to look at. The first is political questions. These are not allowed. Political questions are going to be when the court is asked to do something that impacts one of the other governmental branches' areas of authority. So, for example, let's say that the Supreme Court is asked to weigh in on a particular decision that would impact trade with a foreign country. They are not going to do that. Absolutely not going to do that because that is a political question. That is something that is outside of the government's sphere of influence. I'm sorry, the court's sphere of influence. So they're never going to enter into that sort of arena. And I'm sorry, I just totally got rid of the notes somehow. That should fix it. All right. So now that we've talked about political questions, let's talk about advisory questions. An advisory question is where one branch of the government is going to ask the court to give their opinion on something before it's happened. This was very common in the beginning when the government was asking questions like, hey, is this going to be constitutional or not? And the court expressly doesn't do that. And the reason they don't do that is because of the case and controversy component of their jurisdiction. Remember that what we just said about standing is that a case has to be ripe and not moot. If a law is prospective, meaning that it hasn't been passed yet, and it's asked of the court to render their opinion of what they would do in a specific situation, this case isn't ripe at the moment. And therefore, courts don't do advisory opinions in the United States. All right, so finally, let's talk about next class. We're going to talk about federalism next class. This is a big deal because this is basically the way that our country is established, and any study of constitutional law would be significantly lacking if we didn't talk about the bizarre dual jurisdiction setup that we have. In preparation for that class, you're going to read and brief McCulloch versus Maryland and United States versus Comstock. There is not a discussion board per se for this week. I am going to create a board and ask that if you have any questions about standing, please ask those. If you are a nerd and want to geek out by reading some of the cases, ask me and I'll be happy to give you the list that I used to prepare this lesson. I just didn't really want to confuse you all by giving you a list of cases that you thought you might have to read and brief. So, in preparation for the next lesson, read McCulloch versus Maryland, United States versus Comstock, ask any questions you have about standing. Again, sorry about the delay in this video. It's going up on Sunday night. I expect to have the next one Wednesday or Thursday. No need to read the cases until Friday. That's when I will look at your notebooks next. Thank you guys so much for all the work that you've been doing so far, and I hope you have a great week this week. Talk to you soon. Goodbye.